Good morning, everyone. My name is Erica Zucker. I'm the policy advocate at the Workplace Justice Project at the Loyola College of Law Clinic in New Orleans. On behalf of the Louisiana Workforce Collective, it is my pleasure to welcome you to this webinar on supporting pregnant workers in Louisiana, understanding federal and Louisiana laws that protect the rights of pregnant workers in the workplace. This webinar is part of a toolkit on workers' rights in the workplace that will be a continuing series, so watch for additional webinars in the coming months. If you have questions at any time during the presentation, please type them into the chat. The presentation is closed captioned, and we have an ASL interpretation for people who are deaf and hard of hearing. So please, if you need that assistance, spotlight the interpreter, Ms. Sullivan, and she will be interpreting in ASL for you. I will now turn it over to today's presenters, Marvis Hicks from the U.S. Equal Opportunity Commission, Dr. Leah Raby from the Louisiana Commission on Human Rights, and Cameron Dawson from A Better Balance. They will introduce themselves. Enjoy the webinar.
Good morning, everyone. My name is Marvis Hicks. I am the Outreach and Education Coordinator for the New Orleans Field Office in the state of Louisiana. My co-partner is Marina Guerrera. She's in Houston, Texas, and she's also an Outreach and Education Coordinator. What we do is provide training throughout the state of Louisiana. Next slide, please. This workshop is brought to you by the Louisiana Workforce Collective.
Technology. Okay, ladies and gentlemen, I am Dr. Leah Raby. I am the Executive Director of the Louisiana Commission on Human Rights. I've been the Executive Director for about 23 years, and I'll be presenting to you today about the relationship between the Louisiana Commission on Human Rights and the U.S. Equal Employment Opportunity Commission.
Good morning, everyone. My name is Cameron Dawson, and I'm a staff attorney at A Better Balance. A Better Balance is Southern office in Nashville, Tennessee, where our main mission is to use the power of the law to advance justice for workers who have questions about their rights regarding pregnancy accommodations, disability accommodations, as well as flexible scheduling and paid and unpaid family and medical leave. So I'm happy to join this wonderful panel today to talk about updates in Louisiana's state law. And I'll turn it back to Marvis.
The agenda.
I'm waiting for it to advance. There we go.
Our agenda today, I will provide the overview of the Equal Employment Opportunity Commission. I'll also be speaking on COVID-19 and pregnancy discrimination. There is on the agenda, as you see, the overview of the Louisiana Commission on Human Rights by our own Dr. Leah Raby, updates to Louisiana law on pregnancy accommodations. We'll have questions, and our resources are at the end. Next slide, please. The U.S. Equal Employment Opportunity Commission, our first slide is jurisdiction over allegations of employment discrimination throughout the United States based on the following: race, color, religion, sex, and national origin. National origin discrimination, same sex, pregnancy, all under Title VII of the Civil Rights Act of 1964, as well as unequal pay and wage issues that are sex related under Title VII, as well as the Equal Pay Act. The disability discrimination, which falls under the Americans with Disabilities Act. Next slide, please. COVID-19 and pregnancy discrimination. Due to the pandemic, may an employer exclude an employee from the workplace involuntarily due to pregnancy, even if motivated by a caring concern? An employer is not permitted to single out workers on the basis of pregnancy for adverse employment actions, including involuntary leave, layoff, or furlough. Is there a right to accommodation based on pregnancy during the pandemic? There are 2 federal employment discrimination laws that may trigger accommodations for pregnant employees: the Americans with Disabilities Act and the Pregnancy Discrimination Act, as well as Title VII. The Pregnancy Discrimination Act, also known as PDA. The what? The PDA is a federal law that prohibits unfair treatment of women because of their pregnancy, childbirth, or related medical conditions. The who? Employees working for a private employer with 15 or more employees are covered. How? The law prohibits an employer from discriminating against an employee in any aspect of the terms or conditions of employment, including harassment. Pregnancy Discrimination 101. An employer may not fire an employee because of pregnancy. Example, we don't have pregnant hostesses here. You'll have to go. Or an employee cannot be denied a job opportunity because of pregnancy. Also, other bad treatment because an employee is pregnant is illegal, like cutting hours or reprimands. Workplace accommodations under the PDA. An employee who works for an employer with 15 plus employees may have a right to a reasonable accommodation for pregnancy, childbirth, or a related medical condition, even if the worker does not have a disability associated with their pregnancy, if they provide an accommodation to another employee. Related medical conditions does not include lactation. If an employer provides accommodations to other employees similar to a pregnant employee, but refuses to provide accommodations to the pregnant employee, that could be a violation of the law, and they would need to provide the employee with the accommodation. Next slide, please. Americans with Disabilities Act. How can a pregnant employee ask for an accommodation? The ADA covers employers with 15 or more employees. If a pregnant employee had a pregnancy-related condition that substantially limited a major life activity, including major bodily functions such as high blood pressure, high sugar levels, gestational diabetes, they may have the right to receive reasonable accommodations so long as the accommodation does not impose an undue hardship that is not very difficult or very expensive for the employer to provide. The first step in the interactive process is to tell the employer there is a need for an adjustment or change at work for a reason related to a medical condition. The employer can ask for health care provider notes to confirm the disability. And these notes should be as specific as possible and outline exactly what the employee can and cannot do at work. Avoid vague terms.
The Louisiana Commission on Human Rights. The Louisiana Commission on Human Rights enforces laws that prohibits various forms of discrimination related to employment, public accommodations, and banking and lending practices in the state of Louisiana. We handle complaints such as race, color, sex, age, disability, national origin, sickle cell trait, pregnancy, childbirth, and related medical conditions. We operate under the auspice of Louisiana Revised Statute 512231, which basically created the Commission on Human Rights in 1988, and then we became operational around 1993. And then we have what's called the Louisiana Employment Discrimination Law, which is Louisiana Revised Statute 23301, which gives us the enforcement powers over all of the state's anti-discrimination laws. In addition to, we operate and have jurisdiction over Title VII of the Civil Rights Act of 1964, the Age Discrimination in Employment Act of 1967, which is also called ADEA, and Title I of the Americans with Disabilities Act of 1990, and the Pregnancy Discrimination Act. Now, the work sharing agreement. The Louisiana Commission on Human Rights, it has been designated as a 706 agency, which means we have a work sharing agreement with the U.S. Equal Employment Opportunity Commission. That relationship has been established since around 93, 94, and both agencies have similar goals and jurisdiction. And that's what I'm going to explain to you today. And in this agreement, the EEOC and the FEPA, which is what the EEOC calls the Commission on Human Rights, and any agency where the EEOC has a state counterpart, and the FEPA means we are a fair employment practices agency, or to efficiently provide redress for individuals across the state of Louisiana, based on Louisiana state anti-discrimination laws and federal laws. Now, when a complainant, which is what we call them in the Commission on Human Rights, and EEOC calls them a charging party, files a charge, the non-jurisdictional cases can be transferred by either agency. So that what happens is, because you can't file with both agencies, only one administrative agency will investigate a charge. You can't file with both. We communicate daily. And I literally mean daily. Now, the FEPA should take all cases of mutual jurisdiction as designated by the EEOC as it meets minimal requirements. And both agencies should tell the complainant of their rights to file with either agency. And we do let you know, you can file with either one of us, but you can't file with both. Why? Because your case is considered as dual filed. So once you have filed with either of us, you have met the standard to have filed a complaint with both of us. I know it's a little tricky, but it works out in the end. Any complainant filing against a state entity should be directed to the EEOC. Now, why do we do this? To provide you with the highest degree of impartiality. We don't want anyone to say that the Commission on Human Rights was influenced by anyone. So we will pass your complaint on, though we will receive it in our office. We'll pass it on to the EEOC to make sure that no one can say we were influenced by anyone in any decision that we have issued. And trust me, we have been accused of being influenced by decisions. No case, and that has never happened. Now, unsuccessful mediations with the FEPA should be directed to the EEOC. This is another way, a firewall that we provide the highest degree of impartiality to those that we serve. So what happens is after you have gone through all the phases, or we have offered mediation and the mediation is unsuccessful, you still have the opportunity to pursue your claim through the EEOC, where then you can go and then it could be investigated. So if mediation fails, you still have your rights protected through the EEOC. Now, the EEOC's process, this is just a snippet of this information because it is very intricate, trust me. So once an employee contacts the EEOC for an intake, we will then, and you can do that either via email, via phone, via web, and even walk into the office, even though since the pandemic, most people, you're not walking into anywhere at this time, but we allow individuals to contact us. We listen to your concerns and the issues and the allegations that you have alleged against your employer. Then what we do is draft what is called a charge of discrimination. And now that charge basically alleges what you have stated against your employer. Once we do that, we draft that charge and we notify the employer regarding the information. Now, when you file a charge, it has to be based upon the last alleged act. The last alleged act must have occurred within the past 300 days. Now, with the Commission on Human Rights, because our office exists in the state of Louisiana, that last alleged act must have occurred within the past 180 days. Okay. Now, after we have drafted that charge and we send it off to the employer, we request what is called a position statement. Now, we typically give the employer 10 days to respond to the position statement. Of course, we do give them 10 days, but then they do ask for usually more time to respond. And of course, we work with them and we'll give them as much time as they need. And then we work together. And if we do see that your case is viable for mediation and we can help resolve the issues that have transpired between you all, then we offer mediation. And that can help provide, the speedy resolution to the issues that are transpiring between you all. And hey, everyone is better for it. And then you can go back to work and everything is good. So, but if mediation fails, EEOC will continue with the investigation. And of course, with the Commission on Human Rights, if mediation fails, then it goes to the EEOC investigation process. After the investigation transpires, then the EEOC, or in the case of LCHR, will issue a determination. And after the determination is issued, then we could either go into conciliation or have you. Now, the EEOC is the only entity that can issue a right to sue. And once you get that right to sue, you have to file suit within 90 days. After that 90 days has elapsed, you have lost your right to sue in federal court. Here's a little chart that'll just give you an overview of some jurisdictional timeframes that show the difference between LCHR and the EEOC. So with LCHR, you have 180 days from the last alleged act to file a complaint. With EEOC, you have 300 days from the last alleged act to file a complaint. With the Louisiana Commission on Human Rights, the employer must have 20 or more employees to file a complaint. With the EEOC, the employer must have 15 or more employees to file a complaint. So now, if you have at least 15 or more employees, you can still come to the Commission on Human Rights. And what we'll do is receive it on behalf of the EEOC and then transfer it to their office, just to protect your time frame and your rights. Now, with the LCHR, the employer must have at least 26 employees to file a pregnancy discrimination complaint. And we'll discuss pregnancy in much more detail a little later from Cameron. Now, the EEOC, the employer must have 15 or more employees to file a discrimination complaint. And then with LCHR, employer must have 20 or more employees to file a complaint of equal pay. And then with the EEOC, the employer must have at least one. Now, an employee can also bring a complaint in state court within 1 year of the alleged discriminatory act. This period is actually suspended during the pending review of the EEOC or LCHR for up to 6 months. And it could actually go longer. It really depends on the judge, because they actually know the administrative process, and the courts are just as backed up as our offices are. And as long as you are actually going through the process, they will work with you. And, they understand that they would like for you to resolve the issue before you get to the courts, actually. So filing with the LCHR is not required, though, to pursue a state discrimination claim. You can go straight to state court, but you can't go straight to federal court. You have to have filed administratively with either LCHR or the EEOC to go to federal court. Now, filing with the LCHR or EEOC within 300 days of the date you believe you were discriminated against is required, again, to preserve your federal claims. Now, if you believe that your rights have been violated, you can contact the U.S. Equal Employment Opportunity Commission, and you can reach out to Ms. Marvis Hicks at EEOC.gov or Ms. Marina Guerrera at EEOC.gov, or you can contact the Louisiana Commission on Human Rights, and you can reach us at gov.la.gov, LCHR, or at 225-342-6969. And I thank you very much for your time and attention. I'll turn it over to Cameron.
Thank you, Dr. Raby. And I just want to say again that with all this information, it is recorded and we will be sending it to attendees so that they can review. But it's important to know how these laws are being enforced by these agencies and to reach out if you do have questions to either the EEOC or the LCHR. And also, A Better Balance is here to help workers who have questions about the new Louisiana laws in place if they have questions about their rights to request accommodation. So I just want to share some key updates to the Louisiana state law that may be helpful for you or coworkers that you know that are pregnant. And so the next slide is just going to show some updates on what the law now provides. This past year, Senator Barrow championed Act 393, which went into effect this year on August 1st, 2021. And the new law protects pregnant employees and those who have recently given birth from discrimination in the workplace. Now, before Act 393 passed, a worker could request a temporary transfer to a less hazardous position, but it was still a question as to whether they could request a smaller accommodation like a water bottle or a stool to sit on if they had other needs from their doctor's advisory or their own health needs. And so this new law does provide for reasonable accommodations to employees that have those known limitations that are either related to their pregnancy, if they've recently given birth or they're having complications with their childbirth, or they have a related medical condition, which does include lactation. So you can request either a reasonable accommodation like time off or additional breaks, unless it would pose an undue hardship on your employer's business. And I'll just go into who is actually covered by this law on the next slide. So as we've said before, many of these laws, and especially that fall under the purview of the Louisiana Commission on Human Rights, they do cover employers with more than 25 employees. So if you are working for an employer in Louisiana and you are pregnant or recovering from childbirth or have lactation needs at work and you need an accommodation, this new law does cover you. It also covers applicants. So not just current employees, but if you are currently applying to the job and have told your supervisor or new employer that you have a need for accommodations, they cannot discriminate against you or deny you those accommodations unless it would pose an undue hardship on their business. And I also want to note that this law does apply to the awarding of a contract or subcontract for providing goods or services. So if you have been awarded a contract or a subcontract and you employ more than 25 employees, you may need to provide reasonable accommodations for pregnant or postpartum workers who have needs related to their pregnancy, childbirth, or related medical condition. And before we go into the examples of what a reasonable accommodation could be, it's important to know what an undue hardship exactly means. So this is similar to the it's similar to the Americans with Disabilities Act that Marvis previously mentioned, in that it's the same standard many employers are used to. It means that if it would be very difficult for your employer to provide you with the stool at your station, or maybe very expensive for them to provide you with a reasonable accommodation like additional breaks to pump at work, then that may meet the undue hardship standard for your employer. But this is an interactive process. So your employer cannot simply deny that accommodation. They may need to provide you with an alternative, but there are limits to what that alternative can be. The law does say that unless your employer is doing this for other employees or even groups of employees who need a reasonable accommodation like light duty position, or they may be disabled at work, your employer is not required to create any new additional employment opportunities or a new position for you if you need a reasonable accommodation due to your pregnancy. This may include light duty. They're also not required to discharge an employee or transfer a more senior employee in order to provide you with a reasonable accommodation, unless they're doing this for other employees or groups of employees who need a similar accommodation. So you may want to see how your employer is treating other employees in this case, but a new position or a light duty position could also be a form of a reasonable accommodation if they are providing it for others. And I think one great thing about this law that Senator Barrow mentioned was that it does provide accommodations for women and mothers, so that way they can continue to work on the job and maintain their health. And they're not afraid to be forced on the unpaid leave too early if they request an accommodation. But this law does give guidance as to what is an accommodation and what are employers' responsibilities. So this is not an end-all be-all list. This is just one type of list that is an example to get the interactive process started between employers and employees. But if you find that your accommodation is not on this list, talk with your doctor, talk with your job about if that's a possible reasonable accommodation. But I just wanted to provide a few examples. So this law does include making existing facilities readily accessible for you or usable. You can modify a food or drink policy in order to keep your iron levels high, or to make sure that your blood sugar is at a decent level so that you're not at risk for gestational diabetes. If you need access to a water bottle or snacks, that can also be an example of a reasonable accommodation. And just like the previous version of this law, it does maintain that you can request a temporary transfer if you are qualified for a vacant position. But again, you want to make sure that your employer does not have to create a new position for you unless they're doing that for other employees. And we've also seen just from our free and confidential legal helpline that many workers simply need access to a stool or even additional sitting breaks to make sure that their legs are not swelling or their feet is not swelling, or to avoid back pain. And we've also seen that job restructuring is a reasonable accommodation. If you have coworkers who can help you with heavy lifting, or if you've been given a weight lifting restriction, that is also a form of a reasonable accommodation, along with light duty, if it is available to you and other workers. And lastly, I do want to say that lactation is a related medical condition under the law. And so if you are not covered under FLISA, which does cover workers who are eligible for overtime or who are hourly workers, you may also be covered under this law to request private non-bathroom space to express milk, as well as frequent or longer breaks in order to pump at work, which could be compensated if your employer is providing compensated breaks already. And so you want to see if you are working for an employer that has more than 25 employees, and see if you have a known limitation related to your pregnancy in order to be covered by this law, even if you're not covered under FLISA laws or other break time laws in Louisiana. And also on the next slide, I'm just going to go into what are the employer's responsibilities when it comes to addressing the needs of their pregnant or workers who have just come back from childbirth. And an employer cannot force an employee to take leave if there is a reasonable accommodation available that can keep them healthy and safe on the job. And even though an employer can say that an accommodation may be an undue hardship, they cannot punish an employee for requesting or using an accommodation, or deny them an existing opportunity or a promotion because they have requested or are trying to use an accommodation at work to address their health needs. And an employer cannot force an employee to accept an accommodation that they choose not to accept if they don't have a known limitation, or if that accommodation is unnecessary to perform the essential duties of their job. And we've often seen this when a pregnant worker may not need an accommodation just yet. They are able to fulfill their duties, but their employer may force them onto unpaid leave, or they may try to force them to a lower paying position, and that's not quite necessary. So this law does make sure that pregnant workers and workers who are returning from childbirth are protected against that sort of treatment. And just like before, Dr. Raby mentioned that you can contact the Louisiana Commission on Human Rights if you have questions about this new law and the updates to this Louisiana state law. But you can also see here, these are some frequently asked questions that we've heard, from pregnant workers on our helpline. And I just want to make sure that everyone, knows about this information. So you don't necessarily have to have a disability to get an accommodation. Before this law was in place, a pregnant worker may have needed to have gestational diabetes or high blood pressure or a qualifying disability to be covered under the Americans with Disabilities Act, or they may have needed to see how other workers who are similarly situated in their inability to work were treated, based on policies to request an accommodation. But this is not the case with this new updated law. So you can request an accommodation as it's needed to prevent those sort of health problems from even beginning. And if you had experienced pregnancy discrimination or a need for an accommodation before this law went into effect on August 1st of this year, you may still have legal protections. Depending on your certain situation, you may be covered by those other laws like the Pregnancy Discrimination Act, or even the Americans with Disabilities Act, as Marvis had previously stated. So we definitely encourage you to contact A Better Balance if you have questions, or the Louisiana Commission on Human Rights and the EEOC if you think that your rights may have been violated, to begin that process. And I know this has been a lot of information, but I will say we will share some resources at the end of this presentation, and you can definitely put any questions you have in the chat. But one final question I've heard from our helpline is, do you have to have a doctor's note necessarily in order to request an accommodation related to your pregnancy or childbirth? And here, under Louisiana state law, it's a bit different from federal law in that you may not need a doctor's note in order to make that initial request. But if your employer has a policy for other employees to submit a note, they may ask for a note from your healthcare provider to confirm that you have a medical need related to your pregnancy or childbirth. And it's important to make sure that that note really does outline what you can and cannot do at work and is as specific as possible. So that way your health needs can be addressed and you can continue working and providing for your families. And so we do have on our website, abetterbalance.org, a state-specific page just for Louisiana workers that outlines your rights. If you go to our Worker Rights Hub, you can see if you have questions about how to care for yourself or your loved ones, how to ask for accommodations related to your pumping needs, or even your needs for unpaid or paid medical leave during your maternity leave. You can access this online, but we also want to share our free and confidential legal helpline number on the next slide. And that is 1-833-NEED-ABB. You can call our helpline if you have questions, even if you're not sure if you want to file a case or want to file a complaint. You can contact us and you will talk with a lawyer, and we'll be able to help you understand your workplace rights around caring for yourself and your loved ones. Or you could submit an online form as well. And we do offer this information in English and in Spanish. So if you have questions about your rights, or if you know of coworkers who may have needs related to their workplace rights, feel free to give us a call. And with that, I'll turn it back over to Erica.
Thank you so much to all of our panelists. I also wanted to shout out to Stuart Smith from the Department of Labor Wage and Hour Division, who put some links in the chat to some fact sheets on worker protection. Also, if you are in Louisiana and you have questions about your workplace rights, you can contact the Workplace Justice Project about workplace questions. Our contact information is on an upcoming slide, and I'll put it in the chat. Please complete our survey about this webinar. As I said, we will be doing additional webinars, and we'd love to have your input. And I'd also like to turn it over to Marina Guerra, who will field any questions that came up in the chat.
Hi, good afternoon. I do have a couple of questions, and we do have plenty of time, so this is a good thing. So first question for Marv Visney, EOC. Can you give some examples of accommodations, some accommodations that an employee might be seeking for pregnancy, reasonable accommodations that they may be presenting to their employer? What are some examples of accommodations?
One, leave can be used as or seen as an accommodation for someone who has a need. And as we mentioned in the beginning, when we talked briefly about accommodations, that it's incumbent for an employee to let the employer know what their specific accommodation may be. The accommodation does not necessarily need to be the accommodation that the employee thinks that she needs. But leave can definitely be used as a way of accommodating an individual. And it depends on the circumstances, basically case by case. It was mentioned earlier that this is an interactive process. So the employer as well as the employee should be reviewing needs that will help meet the employer's need, but that will continue them to be able to perform the essential portions of the job. And it was also mentioned that the accommodation cannot create an undue hardship.
And just to kind of piggyback on that question, who would determine that there's an undue hardship? If the employer says that that would be too much or too difficult, who makes that determination?
Basically, looking at the employer's record, the employer would basically make the determination of whether it was an undue hardship on their business, but then that has to be tested as well through documentation.
Thank you. And I think a good point, right, is to know and understand the policy so that because it's a two-way street, the employee understands what their role and responsibility is. I appreciate that information. I have a couple of questions for Dr. Raby. Dr. Raby, are there any benefits of filing with the EEOC versus the Louisiana Commission on Human Rights?
Actually, no, because we do work hand in hand. So you get the same benefit of with each office. Our processes are in sync with each other, and we do follow basically the federal process. So it's aligned, and we work together, literally on the phone daily. Marvis and I speak, and we are a certified FEPA, the Commission on Human Rights is. So that means that we've been doing and investigating charges for so long that the EEOC trust our decisions. So, so we've been, and I've been with the commission for, actually I've grown up with the commission. So I've been with the commission since '95, and we've been investigating in our partnership with the EEOC since fiscal year '93, '94. And we've received our certification status. So it took us a long time to get it, probably like 20 something years. And so they trust now that our decisions are our decisions. And they do review our cases, but every case, and for a while it was every case we had was reviewed, were subject to substantial weight reviews. Now they are randomly substantial weight reviews that are done on just a few of the cases, but you good with either entity.
Thank you for that. And so just a little bit on that question, do all claims that are investigated by LCHR go to EEOC, or how does that work?
Yes. So what happens is, if it's an employment discrimination complaint, after we finish our investigation process of it, because of the work sharing agreement, and to make sure that you are offered an opportunity to pursue your federal claim, then we will then send it to the EEOC. They will review it, and they make a determination if they actually want to pursue it at the federal level themselves. Their legal department reviews it and say, hey, we might want to pursue this at a higher level. If not, if they don't want to pursue the legal claims at a higher level, then that's when they'll go ahead on and proceed and issue the DNR, which is called the right to sue that you'll receive, and then you can take it to the federal court. Now, one thing I do want to stipulate and get this out here, because a lot of people are confused about this and they get frustrated about it. Just because we issue a no cause finding does not mean a violation did not take place. It just means that we did not find something didn't happen. It doesn't mean you can't go to the courts and a different decision is issued or rendered. It means it may have meant that we administratively didn't have the manpower or resources to go dig further into the issues that were presented, whatever have you. It could be all type of incidentals or different circumstances that have transpired. So a no cause finding is not a bad thing. A lot of people become quite combative and argumentative when we issue a no cause finding on a particular charge. It's not a bad thing. We do want to give you your right, though, to be able to pursue it in the courts so that you could yield possibly favorably in that issue. And so, we do want to clarify that.
No, I appreciate that's a really important point. And I do have one more question for you. If you could just kind of a little bit kind of go back over the timing. What is the timing to file with LCHR? What's the timing to file with the EEOC? I think those are important points to make. And then just kind of like, what are we looking at when a person is saying, well, am I at this point? What should they be focused on when they're thinking about, do I have a timely claim with either
Okay.
agency?
So when you're interested in filing a complaint with the Commission on Human Rights, the last alleged act must have occurred within the past 180 days. So whatever the last violation that you're complaining about must have occurred within 180 days. But don't worry, because even if you file a complaint with our office at 181 days, we'll say, okay, that's okay. Because we have the work sharing agreement with the EEOC, you still fall within their 300-day jurisdiction. So we have what's called an intake process, and we'll receive the complaint on behalf of the U.S. Equal Employment Opportunity Commission. So that's because we work in sync with them. So once we receive, and we'll listen to you, we'll interview you, we'll discover what's going on, what has happened, we'll determine, and we'll draft what's called a prima facie charge of discrimination. And we'll listen to you, and we'll place those allegations on the face of a charge. Now, this is another tricky situation. Everything that has happened to you does not go on the face of a charge. We have a lot of complainants / charging parties that want to put a complete dossier on a charge of discrimination. That does not need to be on the face of a charge. It is a very succinct, short snippet of what has transpired. The other information comes out in the investigation part of your complaint, or perhaps mediation. We only need just a little bit, a couple of lines of information just to notify the respondent, because I guarantee they know what has happened or transpired at that entity, to make them aware of these allegations that you have brought forth. And so they get a little zealous in their efforts, and they're going, no, I want this, and I want this, and I want this, and I want this. All of that is not necessary. And so and you can end up defeating yourself when you do that, and you're giving out too much information. We are a neutral entity, but we're there and to help everyone to resolve the issue. But at the same time, allow us to keep the neutral environment, basically. Any other questions?
No, that's perfect. I do have some questions for Cameron. You're not off the hook. We got questions for you as well. On the website, I did share the link to the website, and there's a lot of things your organization assists with outside of pregnancy caregivers. Can you tell us a little bit about some of the cases, not specifics, but some of the cases where you've assisted in? Because I think resources and for people to know where they're going is important. It talks about pregnancy, but it also talks about caregivers. Can you give us a little bit more detail so people will know when to reach out?
Sure, Marina. And I will say too that it is difficult to navigate the enforcement process on your own. So we do talk with workers who are just have preliminary questions about the process, or they do want an attorney to look over things for them or represent them on their behalf. So a lot of times we have helped workers, especially who have been injured on the job, or have caregiving needs during COVID-19 and may work at large retailers like Walmart, and have really bad policies that punish workers who are trying to care for their elder family members, or maybe even injured members who are going through a serious medical condition. So we do work on workers' behalf to make sure that policies at major retailers or even smaller businesses are giving workers the time that they need, so that they don't go back to the job, before they fully recovered, or they're not aggravating those injuries, and they can still, receive a paycheck or a modified schedule. We also do a lot of policy advocacy. So in cases where beyond litigation, workers are interested in sharing their experience in joining the fight for paid sick time or paid family and medical leave, especially when those rights are so important in the South. We do give opportunities for workers to share their experience and join us in that fight, because a lot of times legislators are encouraged and concerned about the workers in their state. So we have those avenues as well. But if you have childcare needs and are concerned about your employer not giving you the time off, or you don't have PTO to use to care for your children or an elderly family member, you can definitely contact us, and we'll, see what laws may be protecting you, or if there's avenues for advocacy there that we can be involved with you in.
That's perfect. And also, I see on the website, it's a kind of a call to action to get behind and to reach out to Congress. Can you tell us a little bit about what we should be doing, what we should or could be doing to help out in this process? Because it is very important. These things are going to keep evolving. So give us a little bit of, a little push on what we need to do to get these things done.
Sure. I mean, I'm all about mobilizing and making sure that, it's not a one size fits all. So if you can sign up on a sign-on letter, we have action pages for both federal and state paid leave on our page. If you're interested in writing an op-ed or a blog post and have questions about even how to get started, you can contact us and we'll walk you through those steps. But I think there's also a lot of movement on the state level, that is inspired by the federal Build Back Better package, to really encourage state legislators to push for these policies for their constituents. And we'll talk more about it on the Equal Pay Summit tomorrow, which we also have a link to. Thank you, Julie, for posting that in the chat. We'll talk about ways to get involved and ensure that Louisiana is a state to benefit working families. So things like childcare infrastructure, things like paid family and medical leave are really policies that can increase, working families and make it sustainable for everyone. So I just want to mention that there are many ways to get involved, and our main goal is to make sure you have the resources and tools, to see what fits your schedule or what fits your interests. But feel free to contact us and we'll get you involved.
I like that. I think you may have already done this, but I'm going to go back and have everybody do their one final important takeaway or takeaway point. Cameron, I'll start with you. What's your one takeaway, one thing that you really want the attendees to take with them today?
I just want to say that, we could not have passed these new updates to the Louisiana law without the stories of workers and without the championing of the passionate championing of Senator Barrow. And so it really is, if you see gaps in the law, if you're curious about how these rights pertain to you, ask questions and reach out, because that's how change is implemented. So knowledge is power, and thank you all for joining today.
Thank you. Marvis, I'm going to turn it over to you. What's your takeaway for the attendees today?
That the Equal Employment Opportunity Commission has still been active since COVID-19. That if you believe that you've been discriminated against based upon your race, sex, national origin, religion, age, any one of the statutes that we have jurisdiction over, feel free to contact us. We are located at www.eeoc.gov. And as I always say, that we look at basically most issues, as long as there is an applicable statute and there are bases. You can contact me at marvis.hicks@eeoc.gov. My phone number is 504-635-2554. And also my counterpart, which is Marina Guerra. She is in the Houston District Office. She will give you her contact information at a later date. But we provide training for both Louisiana as well as the Houston.
Thank you, Marvis. And Dr. Raby, I'll let you close it out. What is your final takeaway for the attendees today?
All righty. Well, I'd like to thank everyone for attending today. And for the Louisiana Commission on Human Rights, I wanted you to know that we are here to provide, we're not just an enforcement agency, but we're here to provide a service for the constituents and the employers for the state of Louisiana. We're here to train, we're here to educate, and I will avail myself to you to provide you whatever you need to make sure that you have an environment for your employers and the employees to make it amicable for everyone, to be a place, because we spend more time at work than we do at home. So, I am here. My phone number is 225-342-6969. And thank you, everyone, for being here and joining us today.
And Dr. Raby, would you just put that last slide up for everyone to close it out?
Let's see.
And we're at time, so I want to say thank you to everybody who attended. We hope this was helpful. And as I put in chat, if there are other areas or topics that you're interested in that we should share or talk to you about, please let us know so that we can make sure that we're aware of that and hopefully put some other events together for you in the future. You've been a great group. I appreciate you.
All right. Thank you.